So I wanted to talk today about California's ballot initiative Transparency Act. In 2014, then Senate President Pro Tem Darrell Steinberg actually authored a bill, Senate Bill 1253. It was enacted signed into law in late September. It was Chapter 697 of the statutes of 2014. Section 1 of the bill established the act as the Ballot Initiative Transparency Act. And Section 2 of the bill set forth a series of legislative findings and declarations to justify the measure. And so the legislature wanted to update the initiative process in that regard. And so Senator Steinberg authored this legislation that requires the Attorney General, upon receipt of a request to prepare the circulating title and summary, to initiate a 30-day public review process for that proposed initiative measure. And then the bill requires the fiscal estimate to be prepared jointly by the Department of Finance and the Legislative Analyst's Office. And then the fiscal estimate that is then delivered to the Attorney General within 50 days. And it had been 25 working days from the receipt of the final version of the proposed initiative measure. Now, this law also extended the date that a petition with signatures on a proposed initiative is required to be filed with the county elections official not later than 180 days from the official summary date. And instead, the law requires the Secretary of State to issue a notice directing the signature verification can be terminated. And the law requires the Secretary of State to identify the date of the next statewide election. SB 1253 also requires the Secretary of State to transmit copies of initiative measures and the circulating title and summary to the legislature, that once they've collected 25% of the number of signatures needed to qualify the initiative measure for the ballot. And then the law requires the appropriate committees of the Senate and the Assembly to hold a joint public hearing on the subject of that measure at least 131 days before the election at which it's going to be voted upon. The law, SB 1253, also requires the Secretary of State to establish processes to enable voters to receive the sample ballot pamphlet in an electronic format instead of by mail, to create an internet website to consolidate information about ballot measures and summaries of each ballot measure, and identify the donors and other sources of funding for the pro and con sides of each ballot measure. In addition, 1253, that bill authorizes the proponents of a statewide initiative or referendum to have the measure withdrawn from the ballot at any time before the measure qualifies for the ballot. And a petition for a statewide initiative measure is required to contain some additional prescribed language in its notice. And that notice is, of course, for the public, that describes the right of proponents to withdraw the measure from the ballot. And then finally, the Ballot Initiative Transparency Act makes it a crime for a proponent of a statewide initiative measure to seek or solicit or obtain any money or thing of value from any person or entity for the purpose of withdrawing an initiative petition after they file it with the appropriate elections official in the state of California. So quite a few changes to the initiative process that were enacted in 2014 by the legislature and governor.